Maintenance is determined specifically. The Swiss code does not stipulate how it is to be calculated. In practice, the one-step or the two-step method is used. The one-step method assumes that there is an abundance of money or exceptionally favorable financial circumstances. Watch this video to find out how the methods differ. My name is Tamara Freiner. I am an independent attorney at law in the canton of Zurich, Switzerland. If you like this video, please share and forward it. Determining appropriate maintenance is a discretionary decision. In principle, the two-step concrete method is used in Switzerland. This was decided by the Federal Supreme Court. The income and living costs of both spouses are determined. A minimum subsistence level calculation with surplus participation is carried out. This savings rate is often disputed. It must be asserted and proven by the party obliged to pay alimony or child support. However, there is no need to argue about details of the previous standard of living. It is assumed that the available funds were used to cover living expenses. This means fewer difficulties of proof for the person entitled to maintenance. Only in the case of very good financial circumstances is the one-sided specific method permissible. It is based on expenses only. Ideally, the party agree on a method. This should be discussed at the settlement hearing. A judge must justify the application of the one-stage method in its court decision. What do exceptionally good financial circumstances mean? This can be the case with net assets of several dozens millions, or with a monthly household income of at least 40,000 Swiss francs. According to the case law, the one-step method is also permitted if both spouses request this, or if the person obliged to pay maintenance is awaiting proceedings. Its income would have to be estimated. The income of the maintenance debtor is not part of the calculation in the single-step method. With the one-step method, the amount of maintenance due is determined based on the previous lifestyle. Expenses are taken into account without considering income. Specifically, the person entitled to maintenance, the dependent, be it a minor child or a spouse, must claim all actual living expenses. They must list and quantify them and, if necessary, provide evidence. This often results in complex, time-consuming court proceedings. The basic amount is often multiplied. For adults, a share of housing costs, health insurance premiums, various insurances, including jewelry and art insurance, communication costs, debt repayment costs, a tax share, and so on, is used. Other items that would otherwise have to be paid from the surplus are added, such as hobbies, vacations, expensive cars, newspaper subscriptions, Botox, or hyaluronic acid treatments. Liposuction, expenses for culture, such as concerts, theater, opera, regular expenses for clothes, shoes, eating out, social events such as balls, sporting events, and so on. Basically, everything for which money was regularly spent should be noted. After determining all living expenses of the dependent, his or her income must be deducted. This results in the maintenance contribution to be paid. Do you know your living expenses and how much you spend? Please note them down. Do you want a fair, amicable modern divorce that you negotiate according to your own ideas? You need professional preparation, a strategy, and someone to support you. Contact me for a joint consultation. And to stay informed, please follow me on social media, be it YouTube, LinkedIn, Facebook, or Xing.